All right, calling us back to order. It is still February 28th, 2023. We're going to pick up where we left off. Let's see, we do have a quorum. Yes. I know there's multiple meetings going on right now. In accordance with Rule 10.05, Representative Finke will be participating remotely by phone with the speaker's approval. Either way, a quorum is present. Today, we've got digital fare repair. I will move House File 1337. Let's see. We're moving that this be placed on the general register. And I understand that you have an amendment. Representative Fischer, would you like us to move that amendment?
Yes, please. If we could move the A2 amendment, and then I can explain it now. Thank you. The A2 amendment just narrows things up in scope a little bit. Instead of the entire Chapter 8, it would be Section 8.31. And this was based on information and discussion that we had in the last committee stop. I want to thank Representative Niska. I know he had an amendment that was a little bit more encompassing that we're not quite comfortable with. But the points that he brought up on the Chapter 8 going to Section 8.31 instead was very good points. And so I'd like to recommend that we add that on.
All right, I will move the A2 amendment. Members, any discussion to the A2? Representative Niska.
Thank you, Madam Chair, and Representative Fischer just stating that I agree with this amendment as well. It's part of what an amendment that I'm proposing as well. And so, yeah, it's a helpful clarification. So I support it.
All right. All those in favor of the A2 amendment, please say aye.
Aye.
Opposed? All right, the motion prevails and the amendment is adopted. We're going to go through the presentation of the bill, and then we'll get to Representative Niska to your amendment after that. So welcome to the committee, Representative Fischer. We have your bill in front of us as amended. Please tell us about your bill.
Thank you, Chair Becker-Finn. And I'm just going to give very quickly on the bill because I know that we're here basically for the subsection 4, enforcement by the AG's office. Basically what this bill does is allow people to be able to have access to the documents, tools, and parts to be able to repair their equipment when it breaks. As an example right now, if your car breaks down, you can take it almost anywhere to get it repaired, but you can't do the same with your cell phone. You can't do the same with your printer or your computer. And so one of the things as we were addressing it is we also needed to have a way to enforce it, and that's where we were looking at having a very limited right under 325D44 for individuals, and then at the same time to allow the Attorney General to be able to do it on a larger size. So I will end at that point. I know there could be lots of discussion on the bill itself, but I want to keep it narrowly focused. I will mention that there is no fiscal cost to it. There was a fiscal note closed. It is zero, and I will stop there.
All right, the first testifier I have on the list is Catherine Morkey. Come on up. Please introduce yourself for the record and then proceed with your testimony.
Thank you. My name is Catherine Morkey. I am an Assistant Attorney General in the Consumer Wage and Antitrust Division. I am speaking in support of this legislation on behalf of Attorney General Keith Ellison and focusing on enforcement by the Attorney General's office. The Attorney General's office would enforce this law the same way the Attorney General's office enforces existing antitrust and consumer protection laws. First, we would do outreach about this new law to manufacturers and consumers. We'd help spread the word about obligations and with education work to prevent violations of the law in the first place. Second, when the office, if and when the office receives complaints, we would investigate those complaints. Usually our focus is on patterns and systemic practices, not isolated incidents. And we are discovering the facts and evaluating whether those show a violation of law. If there is noncompliance with the law, step 3, we often have the opportunity to correct the action without going to court. And this is especially valuable where you can take quick action. And with some of the constituents who support this bill, farmers, time is money, especially so than for many of us in other situations where getting something repaired without waiting for a court action or driving across the state is critical. As a fourth, as a last resort, and if needed, we would file a lawsuit in court that under 8.31, we have the option to seek remedies. They include injunctive relief, restitution and disgorgement, civil penalties of up to $25,000 per violation, and the costs and attorney's fees for the lawsuit. If restitution is awarded by the court determines the award. That goes to harmed consumers, the victims. And if civil penalties are awarded by the court, that goes to the general fund, not the AGO. Thank you.
All right. Next on the list, I have Justin Stoffren. Please introduce yourself and proceed with your testimony.
Thank you, Chair Becker-Finn and committee members. My name is Justin Stoffren. I'm the Anti-Monopoly Director for the Minnesota Farmers Union, which is a grassroots organization representing family farmers, ranchers, and rural communities in Minnesota. I want to thank Representative Fischer, as well as I know there are many co-authors on this committee for their leadership on this legislation. MFU members support this bill broadly as a matter of principle. Farmers should have the right to repair the equipment that they own. Specific to this committee's jurisdiction, though, is the enforcement provisions of the bill. MFU has full confidence that the Attorney General's office will be able to fairly enforce House File 1337, given a track record from the AG's office of using its authority under 8.31 to engage in key litigation helping protect farmers in rural communities. Under its authority under 8.31, the AG's office recently joined 9 other states in the Federal Trade Commission in an antitrust lawsuit against major pesticide manufacturers for using loyalty programs to suppress competition from generic manufacturers. Governor Walz's Executive Order 2010 prohibiting price gouging early on in the pandemic relied on that authority under 8.31. We saw the AG's office use that on multiple occasions to help protect consumers from profiteering. And finally, 8.31 provides the AG's office with the authority to conduct investigations related to a variety of statutes, including antitrust and nonprofit laws. And we've seen the Attorney General's office engage and work to engage in a very thorough investigation of the proposed merger between Sanford Health and Fairview Health Services under that authority. We hope this committee will agree that the Attorney General's office is well positioned to help enforce this legislation and ensure a fair marketplace for repairs in Minnesota. I want to thank you for your time and again to Representative Fischer for his leadership.
All right, thank you. And we do have quite a few members of the public signed up to testify. David Fish and then Lisa Volpe McCabe. Whoever's on deck, if you could maybe grab a chair or get close so we can move things along quickly. We will be limiting testimony to 2 minutes. Please introduce yourself for the record and proceed with your testimony.
Excuse me. Madam Chair, members of the committee, my name is David Fish. It's not any relationship or has anything to do with Representative Fischer, but we're spelled the same way. In any event, I'm here to represent what's known as MINESTA, which is the Minnesota Electronic Security Technology Association. To make it simple, we are basically the alarm industry in the state of Minnesota. About 20 years ago, the state licensed our industry under 326B.33, and it created 2 licenses, one of contractors and one in individuals license. Now, the law specifically states, and I'm just going to read it for you, it makes it illegal for any individual or contractor without a license to install, alter, repair, lay out, supervise any of the activities within the scope of our industry. In other words, alarm systems, fire alarm, life safety, nurse call systems, video surveillance, access control, everything you see in and around this room. Because of that, it's our contention that House File 1337 is in direct conflict with 326B33 by allowing just anybody to step in and work in our industry without the benefit of the training or the license. We've been told that 1337 doesn't apply to licensed trades in this state. If that's the case, it doesn't say that anywhere in the bill or in any of the amendments. So we're asking that you amend 1337 to include language that excludes a licensed trades in Minnesota or our industry, or perhaps excludes 326B 33 through 41 from this bill, this law.
All right, thank you for your testimony.
You are welcome. Thank you.
Lisa Volpe McCabe, and then Tyler Deers on deck. Please introduce yourself and proceed with your testimony.
Chair Beckerfin, members of the committee, my name is Lisa McCabe, and I'm with CTIA, the Trade Association for the Wireless Industry. And in looking at Minnesota Attorney General authority related to this bill, I think there are a number of important issues to consider. The committee was provided a memorandum prepared by Legislative Counsel in Vermont that outlines some legal considerations. It was a big document, so it may not be in your packet, but I know it's online. And many states have looked at this issue, over several years. And in addition to safety and security issues, legal issues have been raised. For example, Vermont Legislative Counsel raised a number of questions from a constitutional perspective. Could this be compared to a law that requires a business to engage with its competitors? Regarding the Dormant Commerce Clause, I'm not a lawyer, but I read the report. Does this bill violate the concept that state regulations may not discriminate against interstate commerce and that states may not impose undue burdens on interstate commerce? Also, could this bill devalue or otherwise hurt existing contracts that manufacturers have with authorized repair providers? Additional legal issues regarding intellectual property and trade secrets and the potential to conflict with federal law also exist. So we feel that this bill raises a number of legal questions. Thank you.
All right, thank you for your testimony. Tyler Deers is up, and then I have Tara Ryan on deck. Please introduce yourself and proceed with your testimony.
Good evening, Chairperson Beckerfin and members of the committee. My name is Tyler Deers. I serve as the Midwest Executive Director for TechNet. We're a technology trade association representing over 100 innovative companies, and we are in opposition to House File 1337. I want to just start off by acknowledging Representative Fischer and thank him for his willingness to continue to hear the legitimate concerns that the tech industry has as the bill is currently drafted. We are working on amendment language, and we do feel that we have it in a pretty good spot and are able to share it with the sponsor in a moment's time. So we hope we can continue the dialogue with the sponsor well after this committee adjourns today. As it relates to the germaneness of this hearing, we do have concerns with how the remedies provision is drafted under subdivision 4. Obviously, we are aware of the amendments that were adopted in committee earlier that seek to clarify the enforcement provisions, and we certainly appreciate that clarification. However, it might just be a philosophical concern, but TechNet is opposed to a private right of action of any sort under this proposal and would ask that any bill that may pass the Minnesota House, among other changes as well, include language that would explicitly prohibit or make clear that nothing under the section may be construed or constructed, to provide for the basis or to be subject to a private right of action. We think enforcement is best handled with the Attorney General, and certainly appreciate the comments that were made earlier by the AG's office. We have several other substantive concerns with the bill as well. This includes privacy for consumers and the information that is stored on their devices while these devices are being repaired. We want to make sure that that information is being protected, especially when the consumer is dropping off their device at an independent or unvetted third-party repair shop. We also have intellectual property concerns as well too with the bill, but I know I outlined those in my previous testimony of jurisdiction, so I won't rehash those, but happy to provide any feedback or answer any questions as it relates to those. So thank you, Chair.
All right, thank you for your testimony. Tara Ryan and then John Keane on deck. Please introduce yourself and proceed with your testimony.
Madam Chair, members of the committee, my name is Tara Ryan. I represent the Entertainment Software Association. ESA represents the three major video game console makers, Microsoft, Nintendo, and Sony, and many of the developers and publishers whose copyrighted works are played on these consoles. I'm here today respectfully to oppose House File 1337. I have submitted written testimony, and I hope that you have a chance to review that, so I'm just going to highlight a few of our concerns with this bill. The bill appears to permit both AG enforcement and a private right of action under the state's deceptive trade practices laws. As we've heard in hearings on this issue around the country, there are individuals who believe that because they own a game console and video games, they should have the right to repair the console. While an individual may own a game console or a video game, they do not own the copyrighted content. For these reasons, we think the bill should be limited to enforcement by the Attorney General's office only. He or whoever is in that seat is in the best position to address any potential violations of this law. That said, we also question whether the Attorney General of Minnesota should be put in a position to enforce this law with regard to game consoles. By granting authority to the Attorney General to enforce this bill as drafted, our members could be subject to unnecessary litigation. House File 1337 fails to recognize copyright protections. Federal copyright law and the DMCA balance the right of the consumer against rights of creators. Section 1201 of the Digital Millennium Copyright Act specifically prohibits trafficking in tools that could circumvent technological protection measures, something that this bill would require. TPMs are the digital locks that video game consoles employ to protect the consoles and to provide a secure media environment for players and other video game publishers and developers. This bill, if passed, would create an untenable position for the video game industry and its copyright owners. A company that exercises its federal right not to distribute the keys to its digital locks would face liability under this Minnesota bill. If the company exercised its federal right, the Attorney General would be in a position to address the violation despite the fact that federal copyright preempts state law. I recognize I'm out of time. The FTC and the Copyright Office have found that video game consoles create a unique situation where piracy is the biggest threat to the industry, and any access to TPMs that allow people to get into that is a big concern for our industry. I'm happy to answer any questions. I encourage you to vote against House File 1337.
All right, John Keane, thank you for your testimony. Please introduce yourself for the committee and proceed with your testimony.
Good evening, Chair, members of the committee. My name is John King of the Association of Home Appliance Manufacturers, also known as AHAM, and we're in opposition to House File 1337. Our industry covers everything from your refrigerator, clothes washer, microwave, without the handling of high-current electricity and refrigerant gases. In regards to enforcement, it is important to remember for appliances, those repairs often occur in people's homes, which raises additional safety and security considerations, meeting certain standards, building codes, energy codes, and whatnot. It also opens a threat to significant property damage, including instances we have heard of using the wrong refrigerant, using counterfeit parts leading to electric shock. I do want to mention that appliance manufacturers are already providing a wide range of repair options, including a nationwide home appliance service repair network, many of them here in Minnesota. The question for enforcement is how this bill enforces against bad actors, people coming into your house and doing improper things. Our repair network provides traceability of repairs. How do you enforce untraceable repair people? To conclude, appliances are complex products that require training and accountability. Untrained repairs can compromise safety and security, and that is why we opposed to this bill. Thank you.
All right, thank you for your testimony. Are there any other members of the public wishing to testify on this bill? All right, seeing none, we will move on to the Representative Niska. I believe it's, you're the only one over there. So Representative,
Back with me.
Representative Niska, would you like to move your amendment and then tell us about it?
I would. So my amendment is the A3 amendment. And first, I think I need to orally amend it to strike line 1.4, which has already been amended
Okay.
to the bill.
Is that correct,
Chair
council?
and members, because they're identical, it's okay. You don't have to
Okay.
find out.
There you go.
So yes, my amendment is the A3 amendment, and I would move adoption of the A3 amendment. And the purpose of the A3 amendment, and again, this came out of discussions that Representative Fischer and I had in the Commerce Committee, where this bill previously was. And really, this is to get subdivision 4 of the bill to align with both the title of subdivision 4 and I think the more rational way for this bill to operate. So subdivision 4 is entitled Enforcement by Attorney General, and I appreciate the explanation that we got from the Attorney General's office about the process that they would use to enforce this law, that they would go through outreach and then investigation, then potentially court action. If that court action was necessary and successful, that they would provide restitution to the individuals who had actually suffered damages from it. And that would, and all of that would be handled in one enforcement action by the Attorney General. I think that is a much better way to handle this type of a law, enforcement of this type of a law, than the Uniform Deceptive Trade Practices Act, which is section 325D.44. So the Uniform Deceptive Trade Practices Act is actually not enforced by the Attorney General. It's only enforced by private individuals. And the reason for that is if you look at the examples in 325D.44, all of the other things that are called out as deceptive trade practices in that section are about individual transactions or limited groups of transactions that are best handled in individual actions brought by the plaintiffs who were harmed in those particular things, like mislabeling of goods or passing off goods as the goods of someone else. This law, in order for it to work the way it's supposed to work, is really much more about the statewide terms that an original equipment manufacturer would offer documentation or tools on. So if you look at subdivision 3, line starting in line 4.20, the actual guts of this bill are about whether the terms that an OEM offers their parts or documentation on are fair and reasonable. So Apple or John Deere or some other OEM is going to, under this bill, is going to offer their parts and tools on certain terms. And either those terms are fair and reasonable under Minnesota law or they're not. In order for, I think, this bill to operate well, if it's going to operate, and I do have some concerns about that we can address later. But in order for it to operate well, I think it's really, really going to be best to be driven entirely through the Attorney General's office, where the Attorney General's office has a dialogue with Apple or John Deere about whether their terms are fair and reasonable. They can choose whether or not to go forward with an investigation. If they choose to, then in Ramsey County District Court or wherever that lawsuit is brought, that's the right place, I think, that case is decided on initial matter on whether the terms are fair and reasonable. If the Attorney General does not go forward, and I appreciate, TechNet saying that they would like to have no private right of action. In an ideal world, maybe I would agree with them. I'm trying to be constructive within the context of your bill. I think that 8.31 subdivision 3A would provide for a cause of action under my amendment. A farmer suing John Deere or a an unauthorized repairer suing Apple would be able to bring that action. They would be able to bring that action stepping into the shoes of the Attorney General, and they would have to show that action would be brought for a public benefit. So I understand that that's maybe a sticking point in terms of thinking about this in terms of 8.31. I do think that in a case in which someone stepping into the shoes of the Attorney General could show to the satisfaction of a district court judge that the terms that an OEM is offering are not fair and reasonable, I think the public benefit standard would almost certainly be met in that circumstance. So I think that's the right way to do it. And the reason why I think the Uniform Deceptive Trade Practices Act really is the wrong way to do it is because in that scenario in which the Attorney General doesn't bring an action, but you have, 100 farmers across the state of Minnesota who think that, and I shouldn't pick on John Deere because John Deere actually just announced a memorandum of understanding with the Farmers Bureau, I understand. But so maybe it's unfair to pick on them, but just using John Deere as an example, if 100 farmers across the state of Minnesota thought that the terms that John Deere is offering are not fair and reasonable, and they brought 100 different lawsuits and different district court judges, I don't want a district court in Candy, Ojai County, and a district court in Stearns County, and a district court in St. Louis County, and a district court in Anoka County to have, come up with 4 different answers, or 3 different answers, or even 2 different answers. I think that's an unfair position to put everybody in, frankly, and I think that that's not really the way that the bill is designed to work. So that's the purpose of the A3 amendment, and it really is offered with an effort to be constructive about a piece of legislation that I don't think on balance is the right approach, but I do think that if we're going to go forward with this piece of legislation, I think this is a really important way to clean it up and prevent some, I think, bad unintended consequences.
Thank you for being so succinct.
I didn't promise to be brief at the beginning.
For an amendment that's like 10 words. Representative Fischer, to the amendment.
Thank you, Chair Becker-Finn and Representative Niska. I appreciate the exchanges that we've had and the discussions on it. And as I've looked at the private right of action, I feel that what is under the AGs is too limiting for it. And what I'm thinking of, and going back to the farm situation, is that, and I'll use manufacturer B so that we don't malign anyone, is that you could have a situation where the farmer needs to get a manual to be able to get a repart done very quickly so they can get going back in the field, and there might be denied. And they need something that's a little bit quicker than going through the AG's office, and I think this is one of the ways that they're able to have some exercise to be able to keep that moving along. And that's one of the reasons I like to make sure we leave it in. I do know that the AG's office is also here, and they could also provide some clarity as to what the differences are between 325 and their current, the way we've got it written for them also. So if you like, we could also have them talk to that.
We'd also like to get to our other bill today.
Yeah,
We've got 3 lines of a bill are before us. Representative Fischer, so do you support or not support?
I'm sorry, it'd be a no. I apologize. I should have been clear.
Any further discussion to the A3 amendment? Representative Niska.
I this time I will be.
Sure.
Yeah, and I just would say that under 8.31, there is injunctive relief that could be brought by a plaintiff. I think that would solve the problem in the particular situation that you're talking about, that they still would be able to bring an 8.31 subdivision 3A action to try to get that injunctive relief. And so I do think, again, I really genuinely am trying to persuade the majority that this is a good amendment. I think that if you're going to pass this bill, this is an important fix to it. So, thank you.
All right. All those in favor of the A3 amendment, please say aye.
Aye.
Opposed? Opposed?
No.
The motion does not prevail. The amendment is not adopted. It was a valiant effort. Well done. Now to the underlying bill, member discussion. Any discussion to the bill? Maybe you've said all the important things that need to be said. Representative Niska.
No, I do. Thank you, Madam Chair. I do still have a couple of other questions. I wanted to start with the fiscal note, Representative Fischer, that assumed 0 costs for the Attorney General's office in enforcement and 0 costs, or specifically didn't account for legal challenges of the legislation. And I was interested to hear a comment on a couple of the items that were brought up, and starting with the dormant commerce clause, whether this discriminates or creates an undue burden on interstate commerce. Do you know whether similar laws have passed and been challenged, and the outcomes of any of those challenges?
Representative Fischer, I'll let you answer that, but the only reason this bill is in this committee is lines 5.1 through 5.3 regarding enforceability. So we're going to stick real tight to that. I'll allow this one, but we're not going to go into any other questions that are outside of The question before us is, should the AG provision be in the bill or not? But Representative Fischer.
Thank you, Chair Becker-Finn, Representative Niska. I know that there's a memorandum of understanding on the car industry. I haven't heard of any challenges on that. And I think there's something similar. Is it Massachusetts? Did some kind of law, but it's very new, and I haven't heard. There's nothing that's been happening. The audit law. Okay.
All right. Anything else, Representative Niska, specifically to the reason that it's in this committee?
Madam Chair, my other questions were about things like the conflict with copyright law. I suppose you're.
I suppose that hopefully was discussed in Commerce Committee. So understand that you really want to talk about this bill, but we do have to stick to the schedule, and we do have people in multiple places. That's obviously why you're by yourself over there. So want to keep us as tight as we can. Any other discussion to the bill as amended?
Madam Chair,
Representative Niska.
I think you're out of order speaking to the motives of members.
It's not speaking to the motives, speaking to the physical reasons they can't be in two places at one time. We do not have time turners. Representative Niska, final comment.
Thank you, Madam Chair. I do have some really serious concerns about whether there are legal challenges that will be successfully brought against this bill, in particular on the conflict with federal copyright law as well. But I do appreciate that we did clarify the Attorney General enforcement provision a little bit more cleanly, and I do hope that perhaps in some further discussions down the line, I can prevail upon the bill author to fix the problem that I think is a serious problem in the way that the enforcement provision is written. So thank you.
And you can have all the time that Representative Fischer will give you, but not in my committee. With that, I will renew my motion that House File 1337 as amended be placed on the general register. All those in favor, please say aye. Aye. Opposed?
No.
The motion prevails. The bill is on its way. Representative Moller, would you like to move House File 1791 be re-referred to the Commerce, Finance, and Policy Committee?
Yes, Madam Chair, that's my motion.
All right, and I see you've got a couple testifiers. Do you want to go straight to the testifiers, or do you have a couple opening comments?
I have a little bit of an opening.
Yep, go ahead.
Yeah, thank you, Madam Chair and members. So I started learning about the problem for consumers with long-term care and long-term disability insurance when I was first elected. Some of my constituents reached out about not getting the benefits they paid for with long-term care insurance. And then I connected with attorney Elizabeth Roble, who I actually used to work with years ago. And I learned that this was a big problem for Minnesotans who lacked a remedy for claims that were denied in bad faith. And my testifiers will provide more information about how this bill works. But please look at the packet of letters that you have describing how hardworking Minnesotans paid for long-term care or long-term disability plans. And then these Minnesotans expected the insurance companies to hold up their end of the bargain if a valid claim was made. What you'll see in both the packet of letters, so there's a stapled packet of letters, and then there's a Department of Commerce complaint logs and summary, is that vulnerable people, often elderly people with dementia or Alzheimer's, are denied by their long-term care plans when a valid claim is made and care is needed. For those who have family members to help them, those family members are spending countless hours getting the runaround from these insurance companies. The victims are expending exorbitant out-of-pocket costs for coverage that they paid these insurance companies for but were ignored or denied. With that, Madam Chair, I will turn it over to my testifiers.
All right, Elizabeth Roble.
And Madam Chair, if my testifiers that are going to, if you're going to just come down and.
Yep, and you can pull up
chairs
some
out.
other chairs. There's plenty of chairs to go around today. Please introduce yourself and proceed with your testimony.
Good evening. My name is Elizabeth Roble. I practice law in St. Paul, and I handle long-term care insurance disputes on the side of policyholders. I was retained in my first long-term care dispute in 2012. I'd only been in private practice a few years, and I had been working in the public sector for well over a decade. Among other things, I prosecuted crimes against vulnerable adults and white-collar fraud schemes against Medicare and Medicaid. My first client, Helen, had severe dementia. Due to family history, Helen's husband insisted that she purchase a long-term care insurance policy in '91. He knew he would probably predecease her, which he did, and he knew she'd probably develop dementia, which she did. Helen paid premiums for over 20 years. By the time she moved into an assisted living facility, she couldn't live on her own safely. Helen's daughter, Marilyn, attempted to assist her with the claims process. By the time I was hired, Helen had been battling the insurance company for months. And despite countless phone calls where Marilyn was provided inconsistent and erroneous answers to coverage questions, and Marilyn providing the company with every single document they requested, denials continued. It was a moving target. Each denial had a different basis. When I took on the internal appeal, I attacked it like a trial lawyer, and I offered all evidence I could to demonstrate how Helen's needs satisfied the policy terms. I even included a videotape of Helen showing her unquestionable memory loss and her inability to keep herself safe. With my near Herculean effort, the company finally paid. When Marilyn learned the news, she called me crying. After months and months of fighting and the uncertainty of Helen's claims not getting paid, Marilyn finally felt vindicated. She was able to honor her father's wishes to ensure that Helen was taken care of and that the care was paid for. Since Helen, I have represented dozens of policyholders in these types of disputes. The facts may vary, the companies may differ, but the egregious claims handling is the same. Ignoring plain policy language, ignoring clear medical evidence, requiring repeated nursing assessments that eventually find the elderly policyholder suddenly ineligible after receiving benefits, differing basis for denial, and the most agonizing delay. Last spring, I made a data practices request to the Department of Commerce. I wanted to see if they were seeing the similar complaints. I received well over 100 redacted complaints that spanned over 3.5 years, and our office created an index so I could look at the substance of the complaints. And what we found was all consistent with what my clients had endured. Policyholders should not be required to pay lawyers to access the benefits they've paid for. Few policyholders have the financial, emotional, and physical wherewithal to take on the complex medical and legal issues that arise and are often fabricated by insurance companies. These long-term care insurance practices are unacceptable, and they can't go unchecked without an appropriate legal remedy. What we're seeking and what we hope you support is an amendment to the Minnesota bad faith law to clarify and ensure that long-term care insurance is not excluded from this law.
Thank you for your testimony. Mark Veda? I don't care, whatever order you guys want to go in, that's just the order you were on the list. Please introduce yourself and proceed with your testimony.
Great, thank you. Good evening. My name is Mark Vida. My father, John Vida, was a Minnesota public school teacher for 30 years. And in 1992, at the age of 64, he purchased long-term care insurance. In August 2019, at the age of 90, my father was living in Eveleth, Minnesota. After a series of falls in his apartment, I was contacted by Essentia Hospital in Virginia, where he was recovering. As my father's only surviving immediate family member, I was informed that my father's dementia had progressed to a diagnosis of severe, and St. Louis County would no longer allow him to be discharged home. The county and the hospital were insisting that he go into a transitional care facility for recovery and further evaluation, with eventual admission into assisted living or memory care. We immediately moved my father into St. Therese of New Hope. My father's on-site assessment at St. Therese confirmed the findings from Essentia Hospital. My father was chronically ill with dementia and had severe cognitive impairment. After a few months, I contacted his long-term care insurance company, Transamerica. I proceeded to submit the required forms and written documents, all confirming my father's condition, as well as the necessary facility licenses. Before Transamerica would move forward with any determination of qualification of benefits, they required my father submit to an in-person assessment by their chosen provider. By now, it was March 2020, and the COVID-19 pandemic had required my father's facility to be under a lockdown. Therefore, this assessment was to be done over the phone. After a 15-minute phone call with my father and the Transamerica nurse, of which my father answered 4 out of 18 questions correctly, it was determined by Transamerica that my father was no longer severely cognitively impaired, and therefore he didn't have a chronic illness as defined in his policy, and therefore he didn't qualify for long-term care benefits. I thought, how could a 15-minute phone call contradict multiple in-person medical analyses spanning many months? Dementia was a progressive disease, and my father's health was declining. My father had paid his long-term care insurance premiums for 26 years, but in his hour of need, his insurance company refused to recognize his medical condition and therefore denied all coverage. My father's financial costs continued to mount. After months of gathering further medical documentation, initiating countless phone calls and emails regarding my father's condition, and after having multiple rejections from Transamerica, I sought legal assistance. I retained Elizabeth Warble as my attorney. Finally, in December 2020, 9 months after the original 15-minute phone call analysis, Transamerica agreed to conduct an additional medical analysis of my father, who thankfully was still alive. This medical analysis confirmed the original findings from August 2019. My father was chronically ill with dementia and required substantial supervision for his own safety due to his severe cognitive impairment. In conclusion, it took months and months of effort involving administrative tasks, legal navigation, medical coordinating, and hiring a private attorney to get my father's long-term care insurance company to fulfill their contractual obligations. Sadly, the time-intensive effort required during this 18-month ordeal not only disrupted my personal career, but also took away meaningful time I could have spent with my father. My father passed away in September 2021. Any corrective legislation to alleviate this experience from other Minnesota residents would be a huge quality of life benefit. Thank you.
Thank you for your testimony. Kate McKinnon, please introduce yourself and go ahead with your testimony.
Good evening. My name is Kate McKinnon. I am an attorney in St. Paul. I focus my practice on disability insurance disputes. Disability insurance is where a person gets an income replacement when he or she is unable to work due to a medical condition. The kinds of disability insurance vary, and the kinds we're talking about here are individually purchased disability policies that are subject to state law, and disability policies provided by employers who happen to be the government or a religious institution. And the reason for that is those are exempt from the federal ERISA law. Otherwise, they would be covered by ERISA. But we need the state of Minnesota to cover those who have individual disabilities or who are state employees or church employees. What happens with a disability benefit is that the individual receives a portion, not complete, but a portion, typically 50 to 60% of their pre-disability earnings while they're disabled. Good insurers pay these benefits, and they pay them timely. However, in my practice, every single day, I see multiple insurers routinely saying no to claimants that have legitimate disability benefit claims. And these are complicated cases, typically involving substantial amounts of medical records and legal issues. So, what can an insured do? Well, we thought in 2008, when Minnesota Statute 604.18 was passed, that there was some little bit of energy to try and equal the playing field a little bit, and that there would be a potential bad faith claim if an insurer denied benefits unreasonably. Unfortunately, in 2021, a federal district court here in Minnesota, in a case called Zimmerman versus Standard Insurance, declared that our statute, our bad faith statute, does not apply to disability insurers because disability insurers, contrary to what most rational people would think, we are health insurers. Disability insurers are health insurers, or that's what the law allegedly said. We're here today to correct this rather tangled piece of statute with a simple fix. It hardly requires any changes to the language, and make sure that the statute covers disability insurance and, among other things, disability insurance and long-term care. And just by completing my statement, I want to just give you my example of one of my clients. And of course, my clients are unable to come here because most of them are disabled. And frankly, a lot of them are on claim or still in dispute with their insurers and don't want to be public. Mr. G, my client, is a county employee in Minneapolis. He has multiple medical conditions involving breathing, walking, eating, and a whole bunch of other functions. He was found totally disabled by the PERA organization, as well as the Social Security Disability Insurance. And by the way, that doesn't mean he got to triple up. Those were benefits that reduced his disability benefits, his employer's disability benefits. Nevertheless, after he had received PERA and SSDI, this carrier said, whoops, nope, you're not disabled anymore. Go forth. This client should have a remedy, and it's going to be hard for him to do anything because, in fact, partial benefits offset by these other things mean he's only going to be out $900 a month. Meanwhile, all that he can collect in suit over this are $900 a month times the number of months that have elapsed since he was cut off. You can't get a lawyer to represent you for that kind of stuff. And yet, that means he can't pay his rent. And we're here today to just make a small change in the statute so that bad faith will fall into the bad faith statute and be covered. Thank you.
All right, thank you for your testimony. The last person I have signed up is Robin Rowan. Please introduce yourself and proceed with your testimony.
Madam Chair, members of the committee, my name is Robin Rowan. I'm the Executive Director of the Minnesota Insurance and Financial Services Council, or MIFSI. MIFSI members promote the financial security of Minnesotans through the sale of products such as life insurance and annuities, paid family and medical leave products, and long-term care insurance. MIFSI members paid out in 2022 over $41 million a day in benefits to Minnesotans. Thank you very much for the opportunity to be here today and to express our concerns about House File 1791. I also want to thank Representative Moller for being very open to discussing our concerns and digging into the issue, even to the extent of watching Senate Commerce hearings from 2008, which not many people will do. House File 1791 significantly expands Minnesota's bad faith insurance law to include not only long-term care and disability, but it also includes other health insurance-related products, including vision, Medicare supplement, blanket accident, income replacement, and dental insurance written by any other company than Delta Dental. This expansion will expose these products to an additional $350,000 in costs beyond the policy limits, increased litigation, nuisance lawsuits, all of which will increase the premiums for these really important products. When the bad faith law was enacted in 2008, and at the risk of giving clues to my age, I will tell you that I was there, and it was very intentionally limited to homeowners and auto insurance only, products that consumers are required to purchase. By contrast, the health insurance health-related products that are targeted by 1791 are voluntary products that the state encourages individuals to purchase. So, for example, Department of Human Services has a Own Your Future division, which is one of their primary focuses is to make long-term care insurance more affordable and available for Minnesotans so that they can take care of their own long-term care needs and stay off of medical assistance. Increasing the cost of this important coverage through unnecessary litigation.
If you can finish your sentence.
Will put it out of the reach of middle-income Minnesotans. I would also just like to say a few additional words that there are significant remedies for people who are experiencing unlawful denials and delays by insurance companies. The Department of Commerce has the Unfair Claims Practices Act, which is one of the strictest laws in the country. It prohibits unreasonably denying or delaying claim payments. Minnesota's law is stricter than other states because it allows, other states will require the department to prove that there's a general pattern in practice. In other words, more individuals have been impacted than just one. But Minnesota law allows the insurance department to take action if an insurance company wrongfully denies or delays one company, and then just one claim. And then very briefly, the log that was referred to by one of Representative Muller's testifiers is not a Department of Commerce log. It's a log that she created, as she correctly stated. But I think it demonstrates that Commerce is actually doing a great job. One of the companies that was mentioned here today, just under half of the complaints in that log were related to one company's behavior. And Commerce Department took action, fined them over $500,000, and then provided remedies in a corrective action plan.
And I'll remind you, this is going to the Commerce Committee, so you'll have more opportunity to testify about the commerce side of things
I know,
when you
but
get there.
I get very passionate about the commerce side of things, so.
Yeah,
I
but this
apologize.
isn't the Commerce Committee, and in full disclosure, I am solo parenting, and we need to wrap up today, so we can't just go on forever about things that aren't within the jurisdiction of this committee. So the reality of where we are, I appreciate your testimony, but we'll ask you to wrap up.
I understand, Madam Chair, thank you. I have a child that I have to get to the airport as well. Insurance companies have to keep their promises, otherwise people don't buy their products. These are voluntary products, and we just don't think encouraging more litigation is an efficient or effective way to protect consumers in this situation. Thank you very much.
All right, thank you for your testimony. Is there anyone else from the public wishing to testify on this bill? All right. Passing the gavel.
Yep. All right, thank you to the testifiers. We'll now open it up for member discussion. Representative Feist.
Thank you, Mr. Chair. I had a question for the experts who initially spoke, perhaps the attorney. I'm horrible for saying that name. Anyway, the attorney who represents folks in long-term care or the disability, actually either. Yeah, so I just heard some conflicting things. I'm sorry. And I just wanted to make sure I had clarity. So I had a couple of questions for the experts. So when you were initially testifying and when Representative Moller was explaining this bill, it sounded like this was a fairly simple line edit that was going to expand the bad faith claims statute to incorporate long-term care and disability. But then our last testifier said that it would actually expand it to include everything under the sun. And so I just wanted to understand where in the spectrum between just these two things and everything this change would actually encompass.
Ms. Rubble.
Sure. The current exception or exclusion is health carrier. And we look at that definition, and we're looking to change it to health plan. Within health plan, there's a bunch of exclusions. One is disability insurance. Another is long-term care insurance. Then there is also blanket accident and a few other line items. That's true. So I think we're talking about a couple different things. First of all, they're kind of trying to weave in this whole floodgate argument. And in all honesty, we have a number of lawyers here, and we've all kind of decided who was going to take what role. And I'm going to ask Kate McKinnon to address that, because we knew that that would be one of the concerns.
Ms. McKinnon.
So I can tell you there will be no floodgate in Minnesota. So what we're doing here, when the bill, the statute in 604.18 was originally passed, the exemptions to the act were very specific, and they were set out in the statute. And they included in subdivision, I think it's subdivision 2 of the original bill, subdivision A3 of the bill, a contract issued by a nonprofit health service plan corporation, number 2, a written agreement of a health carrier is defined in section 62A011. Well, that sounds like really lawyery, but what it did was it was supposed to be health insurers. And instead, we had this language in A2, a written agreement of a health carrier is defined in section 62A011. So then you go to 62A011, and lo and behold, it's a very lengthy definition of health carriers. And then And then there's an exception to the definition of health carrier, and there's in fact 14 exceptions in that definitional section, including Part 1, which is long-term disability insurance, and Part 9, which is long-term care insurance. So what we had was an exception to an exception. And anybody who studied grammar, that's a double negative. It's a positive. But unfortunately, a judge here in Minnesota said differently. The judge saw this as being a way in which disability insurers, long-term care insurers are health insurers. The problem here, what we're trying to do is to get it so that those exceptions to the exception in 62A.011 subdivision 3 are where they always were, which is to say, subject to the bad faith statute. We're not expanding the law. We're just putting it where it always was, but got a little muddled. And so sometimes you have to come here to fix these things.
Thank you. Representative Feist, any follow-up?
Yes. I just wanted to move on quickly to my second question. I just wanted to make sure I understood. So if we aren't incorporating disability and long-term care into the bad faith claims statute, what would be the remedies? Because it seems like if a company commits fraud, that there should be a cause of action. So I just want to make sure I understand, like if we aren't able to do this, then what remedies are there under the existing law?
The only remedy is a breach of contract action under state law.
Go ahead, Ms. McKinney.
Pardon me. The only remedy is breach of contract under state law. And under Minnesota law, absent the bad faith remedy, there is no right to attorney's fees for a first-party insurance dispute. Okay? So that means when your insurance company wrongfully says, no, we're not going to pay you, or we're only going to pay you a small portion, you have to hire a lawyer to get to the place that you should have gotten it without a lawyer. So you're really out the money. So no, there are no other remedies under Minnesota law. And if I might just go one step further, the suggestion was made that the Unfair Claims Practices Act fills this void. It doesn't. The Minnesota Supreme Court has held that the Unfair Claims Practices Act gives the Department of Commerce a right to sue sort of on behalf of the public, but it doesn't give an individual a private right of action. So there are no other rights.
Thank you, Ms. McKinnon. Representative Feist?
Thank you so much. That was helpful.
Representative Niska?
Thank you, Mr. Chair. And the first question I had, Representative Moller, or maybe this is a question for Ms. Robel. This document was given to us in our packets. It's like a 13-page summary document. I think Ms. Robel referenced making some sort of summary, and I was wondering, is that this document?
Representative Moller?
Mr. Chair, yes, that is correct. That's a summary that she made based on her data practices request of Department of Commerce.
Representative Niska?
Thank you, Mr. Chair, and Representative Moller. Just so, and you can correct me if I'm misunderstanding this. So this document isn't created itself by the Department of Commerce. It's something that Ms. Robel, private practice attorney, created based on information she had gotten about different complaints from the Department of Commerce. I think that I'm understanding that correctly. I just want to make sure that we're 100% crystal clear about that.
Representative Moller?
Yeah, Mr. Chair, Representative Niska, that's correct. She created this document. However, just to put a little context to it, we first brought this bill last year. We knew that the industry didn't like it, and so we tried to chat with them, work things out. That's why I looked at the 2008 legislative hearings and listened, tried to understand where this came from. And we were told at the time, basically, show us the proof that this is happening. Show us some evidence that this is happening beyond what these attorneys who do this work were experiencing. And so then Ms. Robel did make that data practices request, and then it's just a way to try to summarize everything, created this document based on that request.
Any follow-up, Representative Niska?
Yes, thank you, Mr. Chair, and Representative Moller. And I don't mean to suggest that there's anything untoward about it. I just want to make sure that we're clear about what
Somebody's phone, sorry, someone's phone was talking.
What the document is. But I did want to move on to address the point Representative Feist had raised, and I think the difference of opinion between Ms. McKinnon and Ms. Rowan isn't about whether this opens the floodgates, it's whether the floodgates already should have been opened before and we're just bringing all of these at least 14 line items, which Representative Feist, anyone is welcome to read subdivision 3 of, 62A.011. There are, it's a very lengthy list of exclusions, which I think now are all brought into bad faith litigation. Many more items besides just disability and long-term care. Perhaps this would be a different discussion if the bill were only limited to bringing disability and long-term care into this. But Representative Moller, I guess my main concern with the bill is it's really, I mean, I definitely have there's no question in my mind that some insurance claims handlers do a bad job of handling claims. Sometimes they're dishonest. Sometimes even companies as a whole have a bad culture and do things badly. It looks like Transamerica certainly was doing that. And so the question really to me is about the best method of enforcing it. And Minnesota does have a little bit different than some other states, which do have more of a Wild West approach to bad faith litigation. We have a very robust Department of Commerce and a very robust Unfair Claims Practices Act that we do that. And then there is an existing individual coverage lawsuit for breach of contract claim. And so I think really the question is whether that's a good way to handle these or whether we need to add the costs of bad faith litigation on top of that framework. The Transamerica example, which is, I do understand about half of the complaints in the summary that Ms. Robel provided for us, it seems to me was handled pretty well by the Commerce Department. So that's not a terribly persuasive reason why we need to change our approach and increase the cost on top of that. So I'm curious whether because we do have, different states taking different approaches, whether we have some way of knowing how individual premiums and vision and dental and things like that are going to go up if we create a potential additional litigation risk on top of those companies, if you know.
Chair Moller, if you could decipher the question, please.
Well, and I'll just start by, because you did reference I'm assuming you're referencing the consent order that involved Transamerica as being, and I know the testifier talked about that, like this is a remedy. They were ordered to pay $500,000. It's my understanding that this consent order is very rare and that this number is something like, and I can ask my testifier to come up and explain that. But what you're hearing from the testifiers today and this complaint log, it is well beyond a problem with Transamerica. That people, if you look through the examples given in this complaint log, people are told to fax information, email, phone calls, constantly to try to get the benefits that they deserve. And they shouldn't have to go hire an attorney, I think, as you said, just to get the benefits that are coming to them. And then who are they going to hire? There are very few attorneys who do this, and they're not getting attorney's fees. And so that's where the problem lies.
Ms. Frovel.
I'd also like to address this. So with the Commerce action, yeah, they did issue a consent order in 2022 for $500,000. What we didn't include is there was also a consent order against Transamerica in 2019. So we're talking about Transamerica having one consent order and then continuing to engage in all the same behavior and then having another consent order in 2020. And then 2019 consent order talks about the fact that the Commerce Department had been investigating Transamerica since 2015. What you need to understand, especially with people who are who have long-term care insurance or disability, they don't have 10 or 15 years to get a remedy, right? My clients are typically on claim for 2 years, and then they die. I mean, most of my policy holders, similar to Mr. Vida, are in their 90s. One of the women who actually wrote the letter in my packet, she's 98 years old, and her husband's 99. and they're just now getting their claims. So so the Department of Commerce serves a very important function, and that's not to say that we don't have robust laws around enforcement. I used to work at the AG's office, and we did a lot of enforcement actions. Serves a great function. But we have something missing. Also included in the packet is a survey of 50 states that talks about bad faith laws in other states. All those other states include exactly what we're talking about. All those other states have enforcement agencies who are just as robust as ours. I don't know that our Department of Commerce is unique, and I will acknowledge that they do a good job. There are a lot of insurance commissioners' offices that do good jobs across the United States, and they still have bad faith laws that are clear about including long-term care insurance and disability.
Thank you, Ms. Rover. Representative Nisko, one more follow-up?
Thank you, Mr. Chair, and Representative Moller and Ms. Roble. I appreciate the concern for that we need to move things quickly. I've done a lot of civil litigation. Getting from complaint to judgment in under 2 years would be quite a feat in a civil litigation case too. So I don't think that saying we're going to channel more of it to civil litigation with attorney's fees is really a resolution to the problem. I think that, frankly, the Commerce Department probably can get people things faster. That's been my experience, that administrative agencies are able to get things faster. But my question really is, and the question I was trying to get at earlier, and I apologize, Mr. Chair, if that wasn't clear, was about the cost that this is going to create. Because insurance companies don't just have free money sitting around. They have, when costs are imposed on insurance companies, that money has to come from somewhere, and it generally has to come from premiums. And so, if we're talking about creating new sources of liability on insurers, including the ones who aren't Transamerica, who aren't bad actors, there are going to be costs. They're going to have to reserve additional costs for litigation and additional potential liability. So how's that going to increase premiums? Is there any way of knowing how that's going to increase premiums?
Representative Moller, if you can.
Yeah, actually, and I'll just turn this over to my testifier, if you can answer that question.
Ms. Frobel.
Well, part of this is a floodgate. I think everybody's always concerned, oh my goodness, the lawyers are going to come storming the courtrooms and suing everybody. And we actually looked up how many lawsuits have been filed and amended. And so with our bad faith law, you have to understand there's essentially 3 gatekeepers before you even get the remedies, right? So the first gatekeeper is you file a complaint and you can't even allege bad faith until the judge says it's bad faith. So there has to be a factual determination by the court to even have that as part of your complaint. The second gatekeeper is to find that bad faith even happened, and that would be the judge or jury. And then the third gatekeeper is the judge who would actually award the damages. So a lot of the research I did, I found a lot of courts actually not allowing the complaint to be amended at all. And then when we looked at I think there were literally just a handful of cases that had these allegations. So this sense that there's just going to be this floodgate and have all these additional costs that are going to eventually be passed on to the policyholders is a myth. I mean, there really isn't. And I think the other thing is, so much of the policyholders, at least I have for long-term care insurance, their premiums have been paid. Right? They've been paying their premiums for 20, 30 years. So that ship has sailed. I can't speak for what the insurance industry is going to do. They seem to raise my premiums all the time, right? So I can't speak to that, but to be concerned that premiums are going to be raised and to deny people benefits, so an auto insurance accident gets bad faith, but my client, John Vida doesn't. Some of our most vulnerable Minnesotans do not have the protections that you and I do through auto insurance and housing insurance. I mean, it just doesn't make sense, and I frankly don't think it's consistent with what the bad faith law set out to do.
Thank you, Ms. Rover. Representative Moller, any closing statements?
I just really appreciate the opportunity for the hearing, and again, want to just take it back to the letters and the packet, the description of how real Minnesotans are getting harmed by bad practices, and they just want their day in court. Thank you, Mr. Chair.
Thank you. Rep. Moller renews the motion to re-refer House File 1791 to the Commerce, Finance, and Policy Committee. All those in favor say aye.
Aye.
Any opposed?
No.
Motion passes. This meeting is now adjourned.